Hi everyone, good morning. I am Santosh Mahapatra. Today I will explain you the most important thing in income tax law, that is the residential status of an individual. The residential status of an individual. So we know that the tax is levied on the total income of an assessee. And under the provision of Income Tax Act 1961, the total income of each person is based on residential status of an individual. So, the term residential status is created by Income Tax Act. It has nothing to do with the nationality or citizenship of an individual. An Indian who is a citizen of India can be a non-resident from income tax point of view, or an American who is a citizen of America can be a resident of India for income tax purpose. So that word residential status is created by the Income Tax Act, and the assessee is going to pay tax on his total income, and how much he will pay, it will be determined on the basis of residential status of an individual. So what is residential status? Let me explain what is residential status according to Income Tax Act. Residential status of a person depends on the territorial connection or the geographical connection of a person with his country. It will mean that how many days an individual stayed in India in relevant previous year. How many days an individual stayed in India in relevant previous year. The relevant previous year is one of the most important thing in determining the residential status of an individual. So it will mean that how many days physically present will determine the residential status of an individual. So the residential status of an assessee is to be determined in each and every year, and it will differ from individual to individual. In every cases, maybe individual, maybe HUF, maybe firm, maybe company, the residential status is determined first, which is related to relevant previous year, then it will decide or determine the total income of the individual, then tax is charged or levied. So here it is the most important thing while determining the residential status of an individual, that previous year is most important thing. Residential status is always related to relevant previous year. It has no business, or it is not related to any assessment year. So here it is the assessee. It is the assessee to prove that. It is the assessee who will provide the necessary document, evidence and material before the income tax authority to determine the residential status, whether he is a resident, not ordinary resident, or non-resident. So from residential status point of view, the tax has divided the individual into three categories. The first category, that is resident and ordinary resident. The second, resident but not ordinary resident. And the third one, non-resident. So it is clearly mentioned in a whiteboard that there will be three categories of an individual from residential status point of view. The first one, resident and ordinary resident. Second, resident but not ordinary resident, and the third one is non-resident. So that is three category of resident basing on residential status. And to determine who is a resident and ordinary resident but not ordinarily resident and non-resident, there are certain tests and conditions which are clearly mentioned in the Income Tax Act. So let me explain what are the conditions or tests to be fulfilled by an individual so that he can claim the status of a resident or ordinary resident or not ordinarily resident or non-resident.